Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. In the last couple of videos, we learned how to handle and manage interest of others in a patent application with regards to being named as a new applicant or getting acknowledged as inventors. In this video, we'll take our journey forward and learn how to handle and manage other forms of interest. Before we move forward, let's jog around the playground once. Let's learn the scenario. Meet the actor who may be directly or indirectly involved in or interested in research and development with regards to a product or a service, or maybe manufacturing a product, or could be selling the product or services, or could be anybody who is not concerned about all of this. As they go through their life around the product and patent, they came to know about a patent application that got recently published. While going through the patent application, they realized that the claims in the current form are seeking such a protection to bring all such activities under the purview of rights as offered by the granted patent. Now, this is a devastating development, and they are not happy about it. And they would want to find ways to continue doing their business with regards to research and development, with regards to manufacturing, or with regards to any business transaction that they take for such product and services which could be relevant to the invention as claimed in the patent application. One such way could be to get in discussion with the applicant of the patent application. Another could be to find ways to not let the patent application get granted. Keeping the discussion part aside, let's see what options do they have to stop the grant of a patent application. So the Patent Act provides them with an option to oppose grant of a patent application. So the Patent Act provides such folks with an option to file an opposition to the grant of a patent. Section 25 relates to such provisions. Now, all such oppositions should be based on some reasonings which are valid and appropriately substantiated. Now, what could be such reasonings? To find such valid reasonings, let's go back to the technical and procedural requirements which were supposed to be met by the applicant for putting the application in order for a grant. Now we can target all these requirements and find discrepancies, if any, to make a solid ground of opposition. What all these requirements were. Now let's start with the very basic one, the ones provided by the definition of section 2 of what is an invention or what is a new invention. So you can evaluate the invention in the patent application to see if the novelty requirements are met, if the inventive step requirements are met, and build upon it. Moving on, section 3 provides a list of subject matters which are not considered invention, and section 4 provides what is not patentable subject matter. You can analyze the invention with regards to those definitions to see whether the invention can be categorized in one of those subject matters or not. Moving on, section 6, which talks about who has the right to apply for a patent. So you can evaluate whether the applicant of the application is the rightful applicant or not, isn't it? Next, section 7 and 8, they talk about various filing forms and the requirement. Specifically, section 8 talks about providing foreign filing details to the patent office on a regular basis. You can evaluate whether such a requirement was met or not, and whether the information thus provided were actually accurate or not. Next is the priority date, as defined by section 9 and section 135. You can check whether this particular application was filed within 12 months from the priority date or not, specifically for convention applications. Next is section 10, basically how a specification should be drafted. It should specifically and particularly describe the invention. And in case of biological material, the source and origin of the biological material should be provided. And if a source and origin is provided, have you provided a right source or not? Such also could be ground of objections. Next is to find prior art references. Basically, any document which was published before the priority date of the patent application and disclosing the invention, or Indian applications which were claiming the invention of these patent application filed before the priority date but published after the priority date. Section 13, the way the examiner deals with it. Of course, such publications that you're finding or prior art references that you're finding should be subject to what is defined as not anticipating under section 29 to 34. Now you can choose one or more of these grounds. Whatever grounds that you choose have to be properly substantiated with respect to the arguments that you make, the evidences that you provide. Now, once you have collected all the documents, you have prepared your arguments, you have created a nice package, you can approach the controller with the packet. Now, how do you file it? As per Rule 55, you are supposed to make representation for opposition using Form 7A, supported by all the statements and evidences that you have collected in the previous step. A copy of same should be sent to the applicant also. You have made the representation, you have done your part. At this stage, the controller will only take up such an opposition matter if a request for examination has been filed for the application. Think of it. Without a request for examination being filed, the patent office anyway is not going to work on the application. Anyway, the application is not going to get granted. So there is no threat, or there is no perceived threat as assumed by you. Therefore, the patent application will not take the opposition matter forward. Now let's assume that the RFE was indeed filed. In such cases, the controller goes over the documents as provided by you, and if he is of the opinion that there is a merit in the opposition filing, what does it mean? It means that the patent application may get rejected based on the statement and based on the evidences that you have provided, may require some sort of amendments before it could be granted. In such a cases, the controller will send a notice to the applicant to this effect. Now, upon receiving such a notice, the applicant are given a time period of 3 months to revert to the controller in case they would want to contest the opposition. So within 3 months, the applicants can come up with their statement, their evidences, countering everything that you have said. And they are required to send a copy to you also. Once this to and fro has happened between the opponent and the applicant with regards to their statement and their evidences, their replies and their responses, controller can schedule a hearing for both the parties to come forward and make their arguments. Once such a hearing is scheduled, both the parties again would submit written statements. Upon going through all the statements, evidences provided by both the parties and the hearings and the written statement, controller will make a judgment with respect to either allowing the representation, in that way rejecting the application, or disallowing the representation and granting the application, maybe with few amendments. So with this, a final judgment is out whether the opposition was accepted or not, or whether the application was rejected or granted. So this provision of pre-grant opposition in fact is a good ground for others to come forward and file an opposition for grant of a patent. This can in fact save them from any inconvenience that they might have faced if the patent application was granted and the applicants would have come forward to enforce their rights. If they can act fast and decisively with substantiated arguments, they can avoid all future troubles. But what if they lose a chance to oppose such a patent and the patent gets granted? Do they have any option? In the next video, we will go through the provisions and the procedures for opposing a granted patent. So I'll see you in the next video. Till then, be good and take care.